allegation that's unsupported by any proof and is actually contradicted by their only witness that they offered to this court, and that was Penny Nolan, who, if you credit her testimony, clearly shows that it could not have occurred as the plaintiff says it occurred. It could not have occurred to the plaintiff, given the fact that Ms. Nolan clearly states that it occurred at her seats, which were benches. The plaintiff has, through her testimony, as well as through her prior trial testimony and deposition testimony, clearly shows that there were no benches that Mr. Springfield was alleged to have stood upon. So if you credit Penny Nolan's testimony, the incident that she describes was not the incident that the plaintiff described.
We have testimony from my client that she was knocked down. We have admissions by the defendant that if he knocked an audience member down, something went wrong and that they should be held responsible for it. That in and of itself creates a question of fact. Counsel wants to argue that to the extent Ms. Nolan's testimony is inconsistent with my client, that's an argument for summation, but right there it's a clear issue of fact. We have, counsel seems to discard my client's testimony as proof. He may not like the proof, it goes to the weight of the proof, but it is proof. And it's for the jury to decide whether or not they believe my client's version was more likely or not representative of what happened, whether Ms. Nolan's version is more likely representative of what happened, whether there's an inconsistency between them. Because if it happened, we have an admission of negligence by the defendant.
There are issues of fact, or an issue of fact that the jury is best left to decide. So therefore, I'm going to deny the motion.